So hello, everyone. My name is Kyle Matthews. I'm Executive Director of the Montreal Institute for Genocide and Human Rights Studies, and I'm very pleased today to be chairing the panel Challenges for Effective Implementation of the Genocide Convention, a very timely discussion. And we're very fortunate to have some speakers here that are being in the news this week about this issue. This is an important global event, a global virtual conference that's focused on commemorating past genocides and learning to prevent atrocity crimes. It's organized by the Liberation War Museum in collaboration with the Montreal Institute for Genocide and Human Rights Studies, the Royal Wallenberg Center for Human Rights, and the Human Rights Research and Education Center at the University of Ottawa, Canada. So we have a very strong Canadian panel today. So first, I'd like to introduce our panelists. So first, and this is the order of speaking. Each of our distinguished panelists will have time to make opening remarks and discuss this theme through their lens. So first off, we're going to have Professor John Packer. John Packer is professor at the University of Ottawa in the Faculty of Law, and he's the director of the Human Rights Research and Education Center at the University of Ottawa. Welcome, glad to have you on here, John.
Pleasure.
Next, we also have another colleague from Montreal who's based, I believe, in Montreal, Canada. We have Jonah Diamond, who's a legal counsel at the Royal Wallenberg Center for Human Rights. Wonderful to have you with us today, Jonah.
Thanks, Kyle.
And last but not least, we have Mustafa Chowdhury. I'm not sure if Mustafa is with us yet. He's a third speaker, and he's an author and a Canadian citizen who originally is from Bangladesh and fled the genocide there and the atrocities and wrote a book about it called War Baby. So we have some very interesting perspectives today. So I would like to now, no need for me to talk anymore. I'd like to pass the floor to John Packer and have him open up the panel.
Well, thank you very much, Kyle, and it's a pleasure to join this amazing initiative, the global collaboration. I'd like to begin by commending the Liberation War Museum in Dhaka and the director Mofadul Hok for conceiving this, or his team for conceiving it and putting it together with all the groups around the world. So we're delighted to be able to link arms with that, with others, and be part of this coalition or this coordinated group, showing how international civil society can work together and actually collaborate thanks to modern technology. So for those who are listening from wherever you are, and those who may follow it subsequently in recording, our panel today focusing on specifically how the Genocide Convention can be made essentially operational. I'm addressing the topic of using the International Court of Justice specifically as an institution or a mechanism. Now, of course, so I'll speak about a couple of things. I'll speak in general, the relationship with the International Court of Justice in terms of genocide, and then some of the comparisons of what gives it comparative advantage, and identifying a few specific aspects that I think commend it. And implicit in this is my encouragement that we use this more, including not as ex post facto adjudication of commissions of genocide, which heretofore has been the case other than the advisory opinion in 1951, but that we think about using it for the other elements of the Genocide Convention, particularly Articles 3, Articles 5, and the whole prevention agenda. So first of all, the International Court of Justice, of course, is the judicial institution of the United Nations, established pursuant to its statute, which is annexed to the Charter of the United Nations. So it's formally part of the instrument establishing the United Nations, the treaty, the Charter of the United Nations. And it should be referenced if you look at Article 33 of the Charter on the Pacific settlement of disputes. It is not only judicial mechanisms as such are named as one of the 8 ways to settle disputes, but the idea of settling disputes without, of course, not only the use of violence or force, but in a deliberative way, according to law, is a commendable approach, part of the rules-based international order that we often speak about. Now, when we look at genocide, this is both prohibited as a action and a crime, so said, of states and of individuals. So breaches of the Genocide Convention as the preeminent source of law for states identify a range of possible breaches. And in particular, it is indicated that under Article 9 of the convention, that in the case of a dispute, and there needs to be a dispute between states, the matter shall be referred, so obligatorily brought to the International Court of Justice. There are at present 152, at least the last time I looked, 152 states parties. So that's 3/4 of the United Nations member states, more than 3/4 are party. A number of them do have reservations, but actually a small minority have reservations to Article 9. So there's actually a wide scope for there to be references to the International Court of Justice. And we could imagine a quite proactive use of the court, particularly if we think about the prevention side. And in that regard, I would refer to the Office of the Special Advisor for the Prevention of Genocide, the Secretary General's Special Advisor, established about 15 years ago, and which has laid out now a lot of analytical tools so that we have a much better sense of what leads to genocide. I think we already had good senses, but now we have a better sense. And so we could, if we apply those, think more again about using the ICJ as one option. There's a lot of them, and I first of all would say that the Special Advisor on the Prevention of Genocide should be more empowered and more proactive, but that's a different issue. Now, if we look at what are the options for judicial consideration of existing breaches, the focus so far internationally has been on individual responsibility. This, of course, we know in the statute of the International Criminal Court, the Rome Statute, but also the ad hoc tribunals. And there have been a number of cases that have been prosecuted. That has led us to some better understanding of some fine points of law. But if we actually look at the consequences of that, we know that the option of trial of individuals is highly problematical. Aside from the fact that you cannot try in absentia, so you've got to arrest somebody, and you have to have a tight case, the standard of proof for an individual's culpability is of the highest level, beyond a reasonable doubt, because it is a criminal prosecution, which may result in long-term incarceration and so forth. But it also suffers from a number of other shortcomings, because if you are a victim group, not an individual, but as for genocide, where the group is the subject, the bearer of the right to be protected, it may not do more than give you a kind of moral satisfaction that after many years, some one or two persons might find themselves incarcerated. I don't want to understate the importance of that, nor of the process of prosecution. But for example, the individual responsibility approach does not offer important elements such as provisional measures. It doesn't offer the option of any significant reparation, and it simply doesn't go to the issues affecting the group as such. And I'll give you one simple example in that regard. As part of the composite of persecution of, for example, the Rohingya, many people probably know that the Rohingya have been rendered, at least de facto, if not, or de jure, actually, as a process of law, stateless. And that statelessness, which has robbed them of their rights and protection within Myanmar, broadly speaking, is not, first of all, is not a crime as such. And second, so it has to be understood in genocide terms as part of the composite of persecution, but it's also not an act that any individual ever did or could have done, nor can repair. It's an act of state. It's an act of parliament, actually, a citizenship law and so forth. So you cannot meaningfully prosecute for rendering stateless, and you cannot repair it. There can be no order to return individually by some individual's act citizenship. So that's a clear limitation on the individual responsibility route. Let me add a couple of other things. A very other major limitation of the route on individual responsibility is that responsible states can well continue business as usual and suffer actually no effect, even find a kind of cover by throwing under the bus a few bad apples, which we started to hear hints of in the Rohingya case, where the idea was, well, maybe it's just the Tatmadaw, not the state, as if there's a distinction in that. And more than that, a few leaders of the Tatmadaw, but everything else is quite okay. And so we could imagine that there might be a prosecution of a few, even still today, individuals, while business as usual continues. The loss of, for example, the expropriation of Rohingya lands, the development, prejudicial development, and all the rest of it would continue with foreign investment and all the rest of it, while individuals might be prosecuted and even found guilty. So I just want to say that, again, this is not to say that the approach of holding individual perpetrators responsible is in any way inappropriate or I'm not supporting it. I'm saying it has its limitations. And so the International Court of Justice, by contrast, has a number of comparative advantages. First of all, it specifically holds the state responsible. And that's very important because the state has that responsibility not only to cease the wrongs, but to repair them. And the state has the means to do that. It has the not only standing, it has the resources, and over time, irrespective of who is in government, individuals can die. We saw that in the Milosevic case. You know, Milosevic was never found guilty because he died. So in the case of state responsibility, the state, presumably, unless it dissolves entirely, doesn't die through the principle of state succession. Whichever government would succeed would still carry the responsibilities. But importantly, as we've seen in the Rohingya case, there is the prospect of provisional measures and even targeted and even refined provisional measures on the basis of urgency and irreparable harm and so forth. And there is this enormous potential of reparations, which has hardly even been treated. But I want to add two or three other elements and then I'll stop. One is, if we think about the International Court of Justice not as a normal court, and it is not a normal court, we can also think about these cases as providing other services in respect of upholding the Genocide Convention and the prohibition of genocide. Not least is the idea of global exposure that comes from the litigation of such a case, or even through an advisory opinion, if it might be thoughtfully articulated, which would have the potential of a kind of truth-telling function. For many, many victims, what they seek of a court is recognition that they exist. This is crucial for the Rohingya, that they were identified as a protected group and therefore they clearly exist when the state itself is denying their existence. So that alone is a kind of victory, or at least an affirmation of an essential element, which is part of what's sought to be protected by the Genocide Convention, recognition. And as another Canadian great sociologist, Charles Taylor, wrote a lot about and taught us, the politics of recognition can be absolutely existential for a group. So the truth-telling exercise not only provides recognition, it also provides the historical record, which would be produced under judicial scrutiny, because this is not just going to be tales that are told, but they are going to be subject to a litigation, a trial, and they are going to be eventually subjected to a judgment, a determination. And so this creates the possibility of a kind of authoritative record of what has transpired. Two other important aspects that I want to mention that have never really been used by the court. Under Article 34 and Article 50 of the statute of the court, there are the possibilities for public international organizations, meaning intergovernmental ones, to contribute. The court does not have an amicus curiae potential or possibility, and civil society and even victims do not have standing, which is, in my view, in this kind of case, a tremendous shortcoming. But there is the possibility that public international organizations could either weigh in with their own views and, for example, provision of evidence, but also be a conduit even for the victims to provide voice. I think this is an important thing that needs to be explored. And the other element here is the court itself has a possibility to establish a commission of inquiry or to call upon experts, which to my knowledge has hardly, if ever, been done. And in these kind of cases would hold enormous potential to supplement the utility of the court as an effective recourse. So I think that this all is to say in conclusion that there are a lot of ways to look at the court and how to engage around genocide that have not really been thought through. It's not just a dispute mechanism for this kind of case for peremptory norms and public interest issues, but in respect of things like the Genocide Convention, it could do so much more contributing to international public order. And I would hope that a number of countries, governments right now, and intergovernmental organizations would realize there's opportunity in this right now in the Rohingya case that we could develop this in a more fulsome way. Thank you for listening to me.
Thank you very much, everyone. That was John Packer of the University of Ottawa giving a really detailed briefing on the issue at hand and the theme of how to implement the Genocide Convention and some of the avenues that we haven't really thought about. So now I'd like to go from John to invite Jonah Diamond. Once again, those joining us a bit late, Jonah is a legal counsel for the Raoul Wallenberg Center for Human Rights. Jonah, the floor is all yours.
Thanks, Kyle. Thanks, John. And thanks to the Liberation War Museum for hosting and the organizers for putting this on. So first, I'd like to quickly go over our findings from our report we just released earlier this week on China's breaches of the Genocide Convention as an important ongoing situation that needs to be immediately addressed. I'll then get into following up on John's points as to how we can use either international bodies or state practice to hold China to account for the genocide. So our report demonstrates very clearly how genocide can happen without necessarily carrying out mass killings. And as the definition in the convention holds, genocide means any of 5 acts committed with the intent to destroy in whole or in part the group as such. Of course, those acts include killing members of the group, causing serious bodily or mentally harm, deliberately inflicting on the group conditions of life calculated to bring about physical destruction, imposing measures intended to prevent births, and forcibly transferring children of the group to another group. And so we've demonstrated through extensive mass of evidence how each one of these provisions has been breached by China. There has been reports of mass death, at least on one occasion within the camps, as well as selective death sentences by execution or long-term imprisonment for Uyghurs or others in their later years. There has been evidence of causing bodily or mental harm through systematic torture within the camps, including sexual violence and brutal methods of torture within interrogation rooms involving electric batons, metal batons, all sorts of, a whole list of disturbing and extreme forms of torture, which have now been verified and corroborated as widespread and systematic within the camps. There is evidence of Uyghur children, and part of that too is important because the mental harm aspect is actually a very serious, all-encompassing trauma that has been inflicted on the Uyghur people as a whole. And each element of this genocide has to be viewed in its whole in order to really fully see how China is effectively destroying the group as such and intending to destroy the existence of the group. Uyghurs of childbearing years are held in unlivable conditions, and birth prevention measures are imposed on women, and there's Uyghurs transferred to forced labor schemes, all contributing to conditions of life calculated to bring about physical destruction, which violates Article 2C. Article 2D, of course, there's well-documented systematic birth prevention campaign in the Uyghur region, which is 90% Uyghur, as well as combined with forced IUD placements within the camps, abortions, and injections, while Uyghur men of childbearing years are detained, even further diminishing the ability to regenerate and reproduce. Then, of course, there is the final act of transferring Uyghur children into state-run Chinese language facilities and Han rearing settings, which is very explicitly forcibly transferring children who have very often lost both parents to either forced labor or the internment camps into state-run facilities. And so the intent, so that's the first element, which are the acts of genocide. And then there is the intent to destroy the group's existence, evidenced by objective measures like overall policy, law, destructive campaigns, selective targeting of leaders. All these atrocities, again, must be viewed in their totality, which amounts to an intent to destroy the group in whole or in substantial part. The government has made statements repeatedly characterizing the camps to wash clean brains. There's a number of statements to eradicate tumors. I don't need to go through the list, but there are explicit statements, but also backed by objective campaigns and atrocities, the scale of which demonstrate an intent to destroy the group's existence. And whatever the government's stated objectives, whether it's counter-extremism, counter-terrorism, it is undoubtedly destroying the Uyghurs as a group and laying the conditions to destroy the Uyghurs as a group, leading to a slow death, which is irrelevant to the question of genocide, to offer some sort of purpose or excuse for carrying out these acts. And the evidence we examined included government stated objectives, government manuals, planning documents, statements, statistics, white papers, reports, expert analyses, and satellite imagery analyses, and the like. And so now I want to move quickly to why our framework of state responsibility, as John was speaking on, is a better framework for seeking justice. Now, China, of course, has signed and ratified the Genocide Convention, though does not recognize jurisdiction of either the International Court of Justice with an express reservation, or the ICC, the International Criminal Court, as it is not a state party, while China also exercises a veto on the Security Council. And so that sort of forecloses a lot of options for immediate either individual criminal liability, other mechanisms to pursue through the UN Security Council in the immediate. And so this approach that we apply is important, and it's practical in the sense that, as John was mentioning, first, it doesn't require the same heightened criminal standard as an individual trial, which would require something closer to beyond a reasonable doubt. And we apply a clear and convincing standard of proof to demonstrate breaches of each provision of Article 2. And that's important because states, the ultimate onus now is on state parties to the convention. As John mentioned, 152 parties, including China. And so now states parties can assess the evidence on different standards than a criminal trial, like reasonable grounds to believe or other preponderance of the evidence standards. We chose a slightly higher evidentiary standard of clear and convincing, but the responsibility, the standard is quite amorphous, and states need to apply at least a reasonable standard to believe that genocide is occurring. And moreover, while genocides have shared characteristics, situations of genocide are very unique and deserve comprehensive attention and unique attention on their own, particularly where in this case, China is using some of the most sophisticated technology to carry it out. And so how do we, as John mentioned, the word is how do we repair meaningfully? That's really key, because how do we pursue accountability meaningfully? And as we've seen, human rights groups, countries have been asking for unfettered access for years, independent mechanism, and those options are increasingly becoming less likely and just unfeasible because for years China has either been excluding or making it impossible to establish an independent mechanism, and they've been more, as of late, expelling major English language reporters from the region. So for this particular, and in addition, this particular genocide is highly sophisticated and systematic, as laid out by the complex hierarchy contained in leaked manuals of officials, entities, and the centralized digital policing system. That to understand the genocide, it's actually it's a better framework to see it through the lens of the state, because you can't necessarily now attribute everything to one individual. And so this must all be seen as an interconnected, systemic genocide. And so while there are challenges for international legal forms of accountability, there are unilateral and multilateral steps that states can take to confront the genocide, as this is a matter fundamentally now, as we know, between states. And so states must start with halting complicity, which is a crime in itself under Article 3, through their supply chains largely. And of course, countries should continue to band together to call for unfettered access, for fact-finding missions through different UN bodies, although again, the concerns are still there as to whether that's a realistic option. Countries can now impose human rights sanctions on the most responsible entities and individuals. They can impose trade sanctions. They can fast-track Uyghur asylum applications, which victims of genocide need immediate protection, as well as relocate or withdraw delegations or athletes from the 2022 Olympics, and similar state actions can be taken. And I'll end there. Thank you.
Thank you, Jonah. You gave a very detailed presentation. And for those of you who aren't aware, there was enormous media coverage this week on a report that Jonah was part of, John was part of, about analyzing genocide convention and the plight of Uyghurs. So if you're interested, just Google, if you Google China genocide, you're going to see all the media coverage and the media impact that report has had. So I would like to introduce next Mustafa, but I don't think Mustafa has joined us yet, if I'm correct. I don't think he is on here. So because he's not here yet, hopefully he will be able to connect with us. I saw that John sent him an email with the link, and I did as well. Maybe there's some technical problems, but perhaps I should move now to field some of the questions from our online audience. I have 2 questions so far, and I'm sure they're much more intelligent than anything I could put together. So I would like to turn to them now. So I'm going to read these off. I think the first one is for you, John. So I'm going to, pose this one to John first. But if you feel like also responding, Jonah, you're more than welcome to. So this is from an anonymous attendee. He says, question to John Packer. How do you think the International Court of Justice can upheld the spirit of the Genocide Convention in resolving the polarization issue between the Rohingyas and the Myanmar government? Would you like to take a stab at that, John?
Well, thank you for the question. And it is actually a very difficult question, but goes to the heart of the matter. I mean, the heart of genocide is the intent by the génocidaire, the either individuals or the state in this case, to destroy the group as such. That's not, it's kind of quite a challenge to be reconciling or to kind of bridge that difference if the other party has that kind of intention. And I must say, in terms of the state, that kind of power. And don't forget that, you know, Myanmar itself has one of the largest armed forces in the world in terms of standing forces, and is an authoritarian, totalitarian in many respects. It's gotten a lot. I acknowledge it's opened up considerably, but 30 years ago it was behind the bamboo curtain, as they called it, and it was very cut off and very much in control. against this population, the Rohingya, who are a relatively small minority, don't count more than 3 million people in the entire world, and only had about 1.5 million people in 2016, 2017, still in a country of about almost 60 million. So a small minority that was peaceful, by the way, not a separatist group, not with an armed militia and so forth. So, kind of, if I may say, jumping to the idea of reconciliation is a heck of a step, but I agree it has to happen. And I'll go back to my reference to Charles Taylor. The first thing is recognition that the group exists and the group has a right to exist. So therefore, it's not to be the object or the subject of destruction. And its right to exist is more than merely as biological atomized beings, a collection of servile persons, which is somewhat what we're seeing in China with the Uyghurs. The right to exist is as a fulsome ethnic or a religious or racial or other group that can actually pursue its full lives in dignity and freedom. That's what's actually supposed to happen. So I would say, the court case, for example, has already, in some senses, addressed this question of existence. The group exists and needs to be recognized and should not be subject to this kind of out-of-hand denial, and coupled with this policy program of destruction. Now, at the same time, I would hope that the court case will also identify what's wrong in detail with the program of destruction. So in the case of the Rohingya, systematic, in the case of the Uyghur also, systematic, widespread, programmatic effort, persecution on the broadest terms. The numbers of human rights violations, the kinds of human rights violations really across the spectrum of human rights that are violated, all of that's going to have to change. And they're should be allowed to live, with not only the protection, the respect, but also the protection of their human rights so that they can restore to full lives and dignity and freedom. And I think that's where then the reconciliation discussion can happen. My hope would be there's a little opportunity right now with the changes in Myanmar, with the challenge to the military regime, where a number of, for example, majority Bamar youth and many of the other ethnic groups are asking themselves, what kind of society do they want as a whole? And within that, there could be a kind of societal bridging or reconciliation, but it must start with the recognition that not only these groups exist, but they are absolutely not to be subjected to this kind of persecution. Sorry for the long answer, but a very, very good and core question. Thank you.
Thank you, John. Detailed in your analysis as always. Jonah, do you have anything to comment on that, or should we move to the next round of questions?
We can move on. I think that's more within John's expertise.
So there's a question coming out for you, Jonah. So maybe, I know someone asked question first, but it's broader, and I think we can turn back to that in a second. I'd like to ask this one. It says, question to Jonah Diamond from another anonymous attendee. What are your opinions in regards to resolving the challenges you mentioned? So you mentioned numerous challenges. Jonah, what are some of the ways that we might resolve those challenges that came out in the report and in the measures to change the behavior of the Chinese government?
Yeah, that's a good question. I would maybe try and clarify whether overcoming challenges, pursuing international legal forms of accountability, or challenges in, I suppose, challenges in holding China to account in general. I mean, it's a similar question, but I mean, for our purposes, and I think in my own opinion, I believe that the ICC and the ICJ and any sort of international court at present would not sufficiently address this situation. And in fact, continuing to discuss those options in some ways can avoid actually confronting China meaningfully. And it's such a powerful country. It might be the world power, And so countries need to band together really to take meaningful action that will influence and put pressure on China, and that includes everything. Everything must be on the table, really, short of the use of force, as John was saying. That that really is a bedrock principle, and so, countries have to basically keep all options on the table. Like I mentioned, a few options. I think the most important, considering that 82, a recent report showed that 82 global brands are potentially benefiting off of forced labor, where where 1 in 5 cotton products worldwide are tainted by sourcing in Xinjiang. So we know how implicated governments are and countries are and corporations are around the world, and so this will really require a response from every level of civil society, government, to band together to put pressure on China, and to avoid complicity, like I said, at the very least, because that's a crime as well under the Genocide Convention. And right now, we know that countries are involved in upholding this system, whether providing elements of the technology being used in the region, or buying cotton products that are, making sure that our supply chains. And there's a variety of options for countries to look at, and it's a complicated sphere in terms of how do you really how do you target the supply chain liability issue. But there are, and maybe John can add to this, there are specific ombudsman offices that countries can have that oversee these, that really ensure that companies are complying with strict laws that will prevent goods being produced with forced labor from arriving in countries abroad. That's a complicated topic, but I think that's the main area that needs to be addressed right now, to ensure that we're not complicit. Then comes, how do we prevent, how do we gain access, how do we continue monitoring to ensure that these atrocities end? Those are important steps too, but I think really starting with influencing the state where they'll actually feel it.
Thank you, Jonah. John, do you have anything to add, or?
Well, just to give a little bit of precision. States not only can, but first of all, arguably have a duty under the Genocide Convention. If there is seen to be breaches of the convention, then this convention operates between, it's a multilateral convention. It operates between, so the duty is not just for the state not to commit genocide itself and then kind of merrily ignore what's going on in the world. So it's not only incumbent under Article 3, for example, not for the state not to be involved in complicity or other means which might give rise, conspiracy and so forth, to commit genocide. But the state generally has, under its jurisdictional authority, the duty to control not only its state agents, but even private actors who might be involved. For example, export. I mean, this was a case of export of chemical weapons to Iraq under Saddam Hussein, for which a chemical company in the Netherlands was, and the owner of it was prosecuted successfully in 20 years ago. And so that's a case. Now, what's important now is there's increasing attention to this with regard to supply chains, and particularly where there would be forced labor. So the UK Modern Slavery Act explicitly establishes both a mechanism, but also penalty. It's a crime to be involved in the importation of products which are produced through forced labor, in breach of not only the long established prohibition of slavery, but also under British law now. And a number of countries are following that. Canada included now has established a Canadian ombudsperson for responsible enterprise. As one example, in France, there's the droit de la vigilance, which creates civil liability for companies that may be identified in civil actions as engaged in such activities. and the European Union, Germany, Switzerland. So this is a trend which is coming, and I think we need to pay attention to it.
Thank you, John. One thing that has me thinking about your comments is that although we have the Genocide Convention, there isn't really a playbook about what must be done right after. We have the Responsibility to Protect, which is trying to build political will, look at challenging notions of sovereignty and tying responsibility to it. But there still isn't like a playbook. This is what you do, and I think every state's different. And I think you mentioned some really important things about the naming and shaming of the Olympics, of the looking at supply chains, looking at Chinese tech companies involved in the surveillance of Uyghurs, and they're trying to get into Western markets, and what we can do to prevent them from doing so, to kind of up our pressure, as well as the increasing use of Magnitsky sanctions, which are a new tool that we didn't really have 20 years ago. So there's a lot of creativity and innovation going on. We have to just keep on pushing to have them carried out by government civil society.
Could I just, Kyle, quickly add to that?
Yes.
So with this kind of palette of new tools that are being elaborated, as you've just mentioned, and many of them are, as you also just said, kind of fairly recent or are in the process of being elaborated. But we also have to recognize the shortcomings. So, for example, the Uyghur case, but even the Rohingya case, show how problematical it is that our established basic kind of fallback, the UN Security Council, doesn't work if the big power, the permanent five interests are affected, or if they are the states themselves which are violating. And we've really not cracked that nut. And what we're seeing now is that, we're always, the Security Council could act, well, it's not going to act in this kind of case. And we actually have to ask what else we can do. I know there's some work being done on that, but I just want to say that your idea of playbook, I want to commend that immediately. I think there's a lot of work that needs to be done and can and should be done to elaborate that playbook.
Thanks, John. And the dysfunctional of the UN Security Council and some of the notions, the responsibility not to veto when there are mass atrocity crimes, is something that people have been pushing, but realistically, I don't see China responding to that. So let's go. Mustafa's not with us, so there must have been a problem with his connection. But there's a question here from Nurul Chowdhury, writing from the University of Saskatchewan in Canada. And this is what she wrote. She says, when a genocide occurs, the countries of the world, specifically the powerful ones, take sides of the oppressors for their own interests of selling arms, maintaining trade and geopolitical relationships. How do we solve this sorry practice by the powerful nations? And so this is kind of touching, John, on the UN Security Council. Maybe mention that during the genocide in Bangladesh, then East Pakistan in 1971, the United States supported Pakistan and continued to sell arms. Would anyone like to talk about this, about the role of states that sometimes do side with regimes that are carrying out these crimes?
You want to start, Jonah?
It's a good question. John, do you maybe want to start? I guess.
So this is really a classic problem of contemporary Westphalian paradigm of international law, which is a state-based system, and classically states follow their interests, and as Nurul, Professor Chowdhury has asked, I think he's put his finger on this problem that, in the pursuit of interests, it's very easy for states to kind of focus on their short-term immediate interests, trade interests, even avoiding the pressure and sanctions that, powers like the USA, China, Russia would press upon them if they would, have the temerity to stand up for the public interest, which is a problem certainly of small states. So, but at the same time, the whole idea of the United Nations, the whole idea of the Charter and of the Genocide Convention is this idea that that there are some bottom lines that are in the general interest. I mean, the genocide is a peremptory norm, which is to say, it is a foundational standard that is obligatory and is not permissible to derogation, not susceptible to derogation. So it must be respected at all times. And it is a duty owed to whom? To the community of all states, to the whole. Now that's amorphous, but it's real. And I think, talking about a playbook, Kyle, for what to do, there needs to be, I think, more work done on this. how does one, there has been work done on, Jan Egeland, former Undersecretary General for Conflict Prevention, and now I think the head of the Norwegian Refugee Council. He wrote a book many years ago about the role of small states who have the kind of capacity to move and mobilize others and kind of generate work in between, And I think we really do have to, the G20 was an effort of something like that, not small states, but mobilizing beyond the P5 and so forth. I think we have to think more now about effective coalitions, how to get kind of, so one interesting thing I'll just say is that at the end of the Second World War, the United States of America was more than 50% of global GDP and was a kind of unrivaled power of the world. Now we have multipolarity. The European Union is more than a quarter of the globe's economy. It's not a military power, but it has military significance, but it has enormous economic reach. China similarly, but China also is not more than about 20%. The USA similarly. There's everybody else. And I think we have to start to think about how we can mobilize that so that we don't all get stuck or picked apart, as Professor Chowdhury has accurately mentioned. I know that's not a simple answer, but I don't think there's many choices, because I don't think we're going to move to supranationality or supranationality. There's not going to be a world government anytime soon, and I think it would be problematical, actually. So I think we have to think in these terms. I hope that somewhat answered or responded to your question.
Yeah, thank you, John. And you made me think also, just this morning, we woke up to find out that the European Union has issued economic sanctions against 4 Chinese officials tied to the CCP, as well as travel bans. So we're seeing some movement, not by national governments, but by a larger kind of, not particularly multilateral like the UN, but an institution that combines many states. Jonah, did you have anything to add?
If I can also suggest that people look up your project of MIGS on the will to intervene. And maybe intervention is not the quite right word here. We're not talking about intervention as such, but the will to act.
Yeah. If I could say a few things, anyone's interested, we wrote a report with Romeo Dallaire. We interviewed American Canadian decision makers about why they didn't do anything in Rwanda in '94, but in Kosovo 5 years later, there's a change, and we outlined a series of recommendations which go beyond the traditional view of it's only the realm of diplomats. We wrote the role of parliamentarians in holding the executive branch account, the role of journalists, the responsibility to report, and how media has a role in mobilizing political will. So there's a whole set of actions there that can really help to kind of maybe other people to think about how to institutionalize capacity within national governments for the prevention of atrocity crimes and upholding the Genocide Convention. Jonah, I think I interjected. Did you have anything to say, or should I move to the next question?
I just want to add. It's for sure. Professor Chowdhury is touching on the biggest challenge right now. Of course, geopolitical, realpolitik, and other forces that are preventing countries from standing up. And part of Canada's, it seems, decision making on this also has to do with acting in concert with our allies, because there's not much we can do alone. Having said that, I think we're at this stage that's before intervening or prevention even, and so I think as genocide becomes the mainstream position and becomes adopted by more parliaments and governments around the world, as democracies, especially countries that care about human rights, the Genocide Convention is a foundational document of the international rules-based order. And so when countries are complicit in this crime, one would hope that there will be enough pressure from the public and political leaders and will to at least stop benefiting from and stop supporting the systems in Xinjiang, and especially relocating the Olympics. That to me is a very simple ask, because why would you promote what is a genocidal state at the moment, on the world stage? I mean, that's a dangerous, I think, slope, because right now we are complicit. Why would we go to the added step of, boosting the reputation of a genocidal state right now?
It's a very, very good point that I agree with wholeheartedly. So we have about 6 or 7 minutes left, not a lot, but we have 2 questions, both from Mujane El Sali. I'd like to maybe pose the first one. She says, seeing that states like Canada have persistently upheld their decision not to recognize genocide, I think that's by the government actually claiming it is a crime of genocide, and thus violating their duty to prevent, are there any actions that these states are not currently taking that they could take to respond to the treatment of the Uyghurs? So are there any steps that perhaps we're not thinking about that they could take if it presented themselves? Anyone have any Nobel Peace Prizing winning ideas for what these governments could do in addition to what has already been discussed?
Well, let me just say that there has been speculation in the Canadian media in the last day or couple of days that maybe Canada's doing a whole lot of things behind the scene. Well, maybe. I've spent a number of years, decades actually, working as an international civil servant, and specifically behind the scenes through quiet diplomacy, preventive diplomacy, and so forth. I would say don't bet on it. There are contacts, but these are awkward topics that most countries seek to avoid. And unless there's a kind of pressing urgency affecting real politics of those responsible, who are mainly concerned with, at this moment, COVID, they're concerned with a prospective election coming and all those other things. Don't expect this is going to take
climate.
Yeah. So just to say, I think, but the duty on the state is to be doing what it can, and there's a range of things that could be done. We've kind of off the cuff identified obvious ones in terms of supply chains, the Olympics, but where is that kind of proactive mobilization of diplomacy? Where is that real effort across the board and systematic, including public diplomacy? Instead, what we see clearly is a lot of shuffling of feet and a lot of passing of time and passing of the buck. If only we had an investigation. We've called for China to accept an investigation. China's not going to accept an investigation. I mean, this is, I would say, reeks of disingenuousness, to be frank. So I think there's a lot to be said, and I think it's up to civil society to press on that. The responsibility sits squarely with states.
And if China, as it has mentioned recently, that its doors are open to Xinjiang, there's also a fear, and a very legitimate fear. What will actually happen is, the High Commissioner for Human Rights will be taken to a show camp. They do have specific show camps where, individuals are still confined and detained. However, the conditions are just not as unlivable and horrific that contribute to physical death, potentially, right? So, and that's happened in the Holocaust too. So that is, and I think it's even worse now. There's more potential for that now when China has such a tight seal on the information leaving the region, and will have a very tight control over who visits and what they see. That's a very important concern.
Let me just add to that. So of course there is the stereotypical Potemkin village. Let's not forget that there really are these Potemkin villages. But I can tell you from my personal professional experience working for the United Nations investigating human rights violations, for example, in Myanmar in 1993, I led a mission and they delayed our visit about a month until they finally agreed. And they did agree that we could go where we wanted. We went to, among others, to Insane Prison to meet some of the political prisoners. And yes, that is its real name, Insane Prison in the Yangon. Ironic title. And it was to the point of laughable, quite literally, fresh paint that was still wet, quite literally nicely potted plants all inside that had just been laid out. and we asked, of course, and people said, oh yeah, this was done in the last 2 weeks. So unless it's a fully unfettered, absolutely unrestrained, and so forth. But I want to emphasize again, and Jonah knows this, we don't actually need to do that. There's abundant evidence in hand. And actually, I don't think it's really a question anymore. The question is what are states supposed to do, should do, and it is actually their duty to come up with those things of what to do, not for you and me to sit here and guess. But I do think civil society can and probably should come forward with more and more suggestions. At a very minimum, I want to emphasize, Kyle, what you mentioned. I just think it is unconscionable that anyone would continue with some kind of a party or a celebration. There was a wonderful piece written the other day pointing out, what's in the actual charter of the Olympic Charter, which actually speaks about human rights explicitly. And the idea that you would go and conduct games while a genocide is ongoing, or even the fair prospect of a genocide, I think you cannot do.
I agree with you, and I agree that there's a role for civil society to play. I've got a piece coming up for Open Canada next week on a whole set of things that can be done, so I'll share that with everyone. They're not traditional, but there could be ways. And I'd just like to add before we close off that I agree with you. The idea of getting in for independent trip into to check on the Uyghurs, we can't count it ever happening. Just look at the World Health Organization's investigation into the outbreak of COVID. It took the World Health Organization a year to get permission. They arrived and they were denied entry to the country for a week. And they had a chaperone tour where they weren't really allowed to do anything. So I think that's not really realistic. So it's exactly 12:30 in the nose. I want to thank the Bangladesh Liberation Museum for organizing this and inviting our institutes to take part. I think it's great to have a Canadian discussion as part of these global virtual discussions. And I'd like to thank John Packer and Jonah from the Wallenberg Center. Thank you for sharing your knowledge with us today.